There has been no specific compelling reason for the seal being raised so far. So this court is unable to analyze what would be a compelling interest based on the motion that's made and been argued. In order to maintain public confidence in our judicial system, it's important that litigation remain open and accessible to the public, absent a valid reason for keeping information from the public eye. A seal must be essential to a decision. Many of the sealed documents in this case will go straight to the heart of the case. And in those situations, it has been held both in the Ballard case, which was the initial case by the courts in setting some sort of standards for the court to review, and that it's also been quoted in the Brentwood Academy case, as well as Kocher. I believe are the two cases on those. I did not and was not provided any case on point in a conservatorship that talks about sealing or unsealing records. The Thompson case is an estate case. Since it's the burden of the defendant to show a need, the fact that the defendant is wealthy is not a basis. The fact that the defendant has a lot of money is not a basis. The reasons for sealing the records must be compelling, using that word again as it's been used many times in this Thompson case. Administrative convenience is not compelling under the Paxton case. Neither is a reason or even a good reason would rebut the public disclosure presumption. Documents used to determine a litigant's substantive right receive the greatest weight and can be sealed only for the most compelling reasons. And in this case, because medical records are universally recognized as confidential, we will make the medical records confidential. And because at this point, unless there's been anything filed after that, but I will look at those documents if anyone makes a motion to unseal them under the two-prong test. Do they contain information generally regarded as confidential, and are they related or unrelated to the case? An unsubstantiated concern would not overcome the presumption of openness. Certain general financial privacy interests have been held not to support a compelling interest. Compelling interest standards demand more than broad or vague allusions to general privacy interests. That's into the Forteroff case. Compelling must be to the extent that it is so great that irreparable harm or injustice would result if not met. And a defendant in this case has not articulated a clear, cogent example of how disclosure of the sealed documents would harm him. So at this point, the court's not putting down a general order sealing the financial records. All right. Anything else on the motion to protect the board? Okay. All right. Ready for the rest of the case today?
Yes, Your Honor, we are. My name is Gary Patrick. We represent the petitioner in this case, Aubrey Preston, who is sitting right here beside me. As your Honor is aware, on October the 29th, we filed a petition for the appointment of a conservator of Forrest Preston. And with your Honor's permission, I would like to, because there's Aubrey Preston, Forrest Preston, and Kim Preston, I would like to refer to using their first name, if that's okay with this court.
That's fine.
The petition set forth, your Honor, why a conservator is necessary for Aubrey's father. As set forth in the petition, Forrest is 91 years old and is experiencing signs of dementia. In addition, Forrest's marriage to Kim Kwon Win, Forrest has been subject to undue influence of his new wife, who is under our allegations is guilty of abuse under the Tennessee Adult Protection Act from elder abuse. We also filed, as your Honor probably knows, a separate complaint under the Tennessee Adult Protection Act against Kim, her sister, and her brother. And her sister and brother, as Mr. Norwood said, is represented by Mr. Norwood's firm. Kim's actions and her background are not only detailed in the petition, but are supported by documents showing transfers of real estate to Kim and her family. The allegations about Kim are also supported by certified copies of court orders from two separate judges in Georgia, where she lost the custody and the visitation rights for her daughter because of sexual molestation. We informed this court that the proof in this matter would probably last 2 or 3 days because it's going to be supported by many, many witnesses. As a result of us informing the court of how much proof was necessary, the court set a hearing for January the 13th through the 15th. And the court also set November the 12th as a date for a status conference at that time. This court entered an order, Your Honor, on October the 29th, requiring Forrest Preston to submit to an examination within 10 days of the date of the order. The examination was to be conducted by Dr. William Ray, who is an expert in giving cognitive tests, and by Dr. Tom Devlin, who is not only Forrest Preston's personal physician, but he is a nationally recognized neurologist.
Give me that name again.
Yes, Your Honor. Dr. Tom Devlin, D-E-V-L-I-N. That's Mr. Preston's, Forrest Preston's personal physician. The court also appointed the attorney Catherine Lentz as the guardian ad litem on the same day. Excuse me. With the assistance of the private process server and 3 Bradley County deputies, Forrest Preston was served with the petition on the same day, October the 29th, and which is quite a story within itself I will not go into now. In addition, Kim Preston was also served with the complaint involving the Tennessee Adult Protection Act. So on both days, on October 29th, both Forrest Preston and Kim Preston was served. As I understand from Ms. Lentz, she made arrangements with at least one doctor for an appointment for Forrest to be examined and given a cognitive test. And Forrest Preston informed her, or someone informed Ms. Lentz, that Forrest and our Kim have refused for Forrest to be examined by either one of the doctors pursuant to this court's order. Now, yesterday, we received a response to our emergency petition, and attached to the response is an affidavit of an osteopath, Paul Grayson Smith III. In the affidavit, he says that he has managed Forrest's medical care for the past 4 years. Of course, we're not sure what managed means. And in his opinion, Forrest has full functional capacity to handle both his health care decisions and financial affairs. That's a quote. However, he does not address the financial affairs of life care. In addition, there is a complete absence of any statement that this particular person, this osteopath, administered any cognitive testing on Forrest Preston. So there is nothing in the affidavit that says that we administered any type of cognitive test and that he passed the cognitive test or the result of the cognitive test. In addition, there are no qualifications of this person, this Paul Grayson Smith, no qualifications set forth in his affidavit that he even has the qualifications to give a cognitive test. The affidavit does not indicate that anything was given or administered that would even support any type of conclusion in his affidavit. The affidavit simply sets forth a conclusion without any supporting data whatsoever, without any supporting documents. What we do know, Your Honor, from the search of public records is that on July 5th, 2022, Forrest Preston conveyed and deeded a piece of property to the same person, Paul Grayson Smith III. That was on July 5th, 2022. We also understand, Your Honor, that the guardian ad litem, Ms. Lentz, has had at least, before this week, at least 2 meetings with Forrest Preston. And fairly extensive meetings with Mr. Preston. And then when Ms. Lentz met with Mr. Preston this week, and of course this is only within a time period of like 3 weeks since the complaint was filed, petition was filed, that Forrest Preston did not know who Ms. Lentz was, despite having met and discussed this matter with her on 2 separate occasions. In any event, Your Honor, Mr. Preston has not been examined by the 2 doctors that this court specifically ordered that he be examined by within 10 days. That 10 days expired November the 8th. Forrest and Kim have refused to obey this court's order. We then discovered very shortly after we filed the petition, Your Honor, that Kim Preston accessed Life Care's facilities at 9 o'clock at night, specifically 9:06 at night, when no one else was in Life Care facilities, 1 day after she was served with the petition, October the 30th, 2024. That statement is supported by a declaration of Scott Curtis, which we have filed with the court. And Mr. Curtis is the employee at Life Care, as set forth in his declaration, that is responsible for the security at Life Care. We also discovered, pursuant to Janice Say's declaration, which is also on file in this proceeding, that Kim Preston and her family, the other defendants in the Tennessee Adult Protection Act, are planning a trip to Vietnam. This is set forth in Janice Say's declaration, where Kim and her family, of course, are from. And not only that, Kim has requested that her brother, who still resides in Vietnam, locate suitable real estate in Vietnam for purchase. Ms. Say's declaration goes further and states that on October 30th, 1 day after she was served, after we filed this, Kim Preston asked that Janice Say assist her in getting Forrest's passport renewed, 1 day after she was served. Thus, Your Honor, we filed this petition for appointment of emergency conservator in this particular case. And we believe that in this particular instance, an emergency conservator is absolutely needed for a lot of reasons, which I'm going to go through right now. In addition to Scott Curtis's declaration, Your Honor, and Janice Say's declaration, we have 8 other supporting declarations. And for your court's convenience, everybody has the declarations that we've served on. For convenience here to follow this, I will hand you the declarations that I'm going to be talking about today. There's one missing out of here, but the rest of them are in there.
Okay.
One affidavit, Your Honor, is from Todd Fletcher. Mr. Fletcher is the president of Life Care. He has worked for Life Care since 1990, so he's been there for 34 years. This is tab 1 in this binder that I gave to you, Your Honor. He has known, Todd Fletcher has known Forrest Preston for approximately 50 years. He states that Forrest Preston erratically attends to Life Care's business operations. He also states that Forrest Preston is often absent for weeks, sometimes over a month at a time. He states that Forrest Preston has failed to provide essential documents necessary to prevent a default under loan documents until the very last minute. Forrest Preston's actions, according to Todd Fletcher, the president, actions during the past few years is unlike his actions in the past. Paragraph 12 of Mr. Fletcher's declaration says that Forrest, moreover, historically understood the nuances, issues facing highly regulated businesses like Life Care, but he no longer comprehends even some of the more basic aspects of Life Care and its affiliates' business operations. Paragraph 13, Mr. Fletcher states that Forrest, in fact, regularly exhibits confusion about routine matters in his daily life that are far less complex than the business issues he contends with at Life Care and its affiliates. Paragraph 14, based upon Todd Fletcher's personal observations, I believe that Forrest is mentally disabled. This is Todd Fletcher, I'm just reading his declaration. I believe that Forrest is mentally disabled with respect to making important decisions relating to Life Care and its operations, and I do not believe that Forrest has the capacity to understand and execute legal documents on behalf of Life Care and its affiliates. And Mr. Fletcher goes on in paragraph 15, I'm not going to read all of that, but he states that there are significant and immediate decisions that need to be made on behalf of Life Care and its businesses that have a, quote, critical need to act on behalf of Forrest. This need is urgent, according to Mr. Fletcher, and Mr. Fletcher states that these decisions must be made before the January 13th hearing date. Mr. Fletcher goes ahead and states that he has known Aubrey Preston for approximately 50 years. He states that Mr. Aubrey Preston has the knowledge and experience to act on Forrest Preston's behalf. Todd Fletcher states that Life Care needs direction from Aubrey Preston to protect Life Care's operations. Todd Fletcher also details Kim Preston's interference with Life Care's, Kim Preston, of course, is Forrest Preston's wife, interference with Life Care, despite the fact that she is not an officer nor employed. He states that she has interfered and disrupted board meetings and the workplace in general. He states that Kim Preston has threatened the jobs and livelihood of both Life Care's employees and executives, and in one instance, even threatening an employee with a gun. Todd Fletcher states that he realizes the statements made in his declaration obviously could jeopardize his job. He believes that Aubrey Preston needs to be appointed the conservator immediately. Now, this is from the president of Life Care. Under tab 2, Your Honor, we have the declaration of the Chief Financial Officer of Life Care, Steve Ziegler. And I would add that both Todd Fletcher and Steve Ziegler are on the board of directors of Life Care as well. Steve Ziegler confirms the statements basically made by Todd Fletcher. Mr. Ziegler has been the Chief Financial Officer for 25 years. He has known Forrest Preston for 35 years. He states that Forrest Preston erratically attends the Life Care's business operations. He says, just like Mr. Fletcher says, that he has been absent for weeks and sometimes over a month at a time. He also confirms that there are critical decisions that have to be made, that Forrest Preston has failed to execute loan documents until even the last day before the default deadline, and that Life Care is a very highly regulated business. In paragraph 12, under tab 2 of Steve Ziegler's declaration, he states that Forrest, moreover, historically understood the nuances issues facing highly regulated businesses like Life Care, but he no longer comprehends even some of the more basic aspects of Life Care and its affiliates' business operations. Forrest, in fact, regularly exhibits confusion. This is paragraph 13 of his declaration. Forrest, in fact, regularly exhibits confusion about routine matters in his daily life that are far less complex than the business issues he contends with at Life Care and its affiliates. Paragraph 14 of Steve Ziegler's declaration. Based on my personal observations, I believe that Forrest is mentally disabled with respect to making important decisions relating to Life Care and its operations. And I no longer believe that Forrest has the capacity to properly understand and execute legal documents on behalf of Life Care and its affiliates. He also confirms that Life Care has significant business decisions to make immediately and is in need of someone to act on Forrest Preston's behalf. Mr. Ziegler states in his declaration that he has known Aubrey Preston for 35 years and that Aubrey Preston is the appropriate person to be entrusted to act on behalf of Forrest Preston. He also confirms that he is concerned with being terminated by Kim Preston, who is not an employee, who is not an officer, who is not on the board of directors, based on historical actions by Kim for giving this declaration. He's detailed how Kim has accused employees and executives of Life Care of misappropriation and bribery when Life Care wasn't generating enough money to satisfy her. Steve Ziegler also believes that Aubrey Preston is the appropriate person to act on behalf of Forrest Preston, and that Life Care will sustain substantial harm unless Aubrey is appointed to act on behalf of Forrest Preston. Your Honor, we also, I'm not going to go through all the declarations, and they're going to be a lot shorter, but these are important, obviously. Under tab 3, Your Honor, we have a declaration that we filed on behalf of John McMullen. John McMullen, Your Honor, is a certified public accountant. Per his declaration, he's known Forrest Preston for 50 years. He also was on the board of directors of Life Care for over 30 years. And per his declaration, he considered Forrest Preston one of his best friends. He and Forrest would talk 2 or 3 times every week. That continued until December the 27th, 2023, when he resigned from the board. He believes, paragraph 8 of his declaration states, I believe that Forrest is mentally incompetent and under the control and influence of Kim, which she is misusing to alienate Forrest from his friends and family, including me. Forrest Preston, John McMullen was named as the executor for Forrest Preston's estate by Forrest Preston. Forrest Preston also gave Mr. McMullen a power of attorney. And Forrest Preston also named John McMullen as his conservator if one was ever needed. And as Mr. McMullen set forth in his declaration, he does not want to be the conservator, and not in his declaration, but I add this: he is a resident of Georgia and therefore cannot serve as conservator over his finances in any event. He has known Aubrey Preston for many years and considers Aubrey Preston an astute business person. He has known Aubrey Preston has been in the healthcare business for many years. He believes Aubrey Preston would be the best person to serve as the conservator for Forrest Preston. Yeah, we also have a declaration from a lady called Esmeralda Lee, and I did not include that in the notebook. And I'll just go over this, and I've got an extra copy here. It just saves you from finding that in the pleadings. But Miss Lee is the chief operating officer and executive vice president of Century Park. Century Park is an affiliate of Life Care, and Century Park owns 42 units or buildings as an affiliate of Life Care. And she described how Kim has orchestrated taking money out of Century Park, and how Kim has accused Miss Lee of mismanagement and theft from Century Park. She also says in the declaration that how the withdrawal of money by Kim and Forrest Preston from Century Park has damaged its operations. And she says in a declaration that Forrest Preston is under the control and influence of Kim. And that Kim has told Miss Lee that she carries a firearm. In paragraph 13, Your Honor, and I will hand this to you, I don't have an extra copy. Thank you. In paragraph 13, she says, Forrest cannot understand what is going on in these meetings and cannot focus or stay on the topic of conversation, and he generally defers to Kim about whether to take distributions or to make capital contributions to fund capital or other needs of a property. Whenever I make progress with Forrest during these meetings, Kim will intervene and I will have to begin again, and Kim almost always makes the final decision as to financial issues. She believes that Aubrey Preston is the best person to serve as the conservator for Forrest Preston, Your Honor. We also have a declaration, Your Honor, from a lady by the name of Lisa Lay, and that's under paragraph 4. Ms. Lay has worked for Life Care for 30 years. She is a senior vice president of Treasury, and she has also served on the board of directors of Life Care. She confirms that she does not want to be the conservator, and she believes that Aubrey Preston would be the best person to serve as the conservator of Forrest Preston. So, Your Honor, as of last year, there were 5 members of the board of directors, as we understand it. Forrest Preston was one of them. The other board of directors were Todd Fletcher, Steve Ziegler, John McMullen, and Lisa Lay. All 4 of those board of directors have confirmed that Aubrey Preston is the best person to serve as the conservator for Forrest Preston, Your Honor. We also have a declaration, Your Honor, from Aubrey Preston's sister, Kathy Gooch, which is in tab 5, and an affidavit from Aubrey Preston's brother, Brian Preston, who is here in the courtroom today, that they have no desire to be the conservator for Forrest Preston, and both believe that Aubrey Preston would be the best person to serve as conservator for their brother. Your Honor, as detailed in Aubrey Preston's, a little bit about Mr. Preston, Aubrey Preston now, and that's under tab 7. Aubrey Preston, born and raised here in Cleveland, Tennessee. Obviously, he's the son of Forrest Preston. He worked at Life Care as Director of Acquisitions and Development in the early stages of Life Care. Well, Aubrey Preston was in that role, the role of Acquisitions and Development. Life Care grew from 28 facilities to 90 facilities. Aubrey and his father jointly, during that time, jointly owned some facilities, and they agreed that Aubrey Preston should start his own company, and they divided up the facilities, Your Honor. Aubrey Preston then began a company which is still in operation.
Not to interrupt, Mr. Patrick, but you're referring to tab 7. What is under tab 7?
That's the document he just handed us.
Okay.
Declaration of Aubrey Preston.
It is the declaration of
Thank you.
Aubrey Preston. He, Your Honor, thank you. Denver Health Group acquires, develops, and manages healthcare facilities, Your Honor, per his declaration. Aubrey Preston now lives in Nashville, but spends a considerable amount of time in Southeast Tennessee, and per his declaration, he will, if appointed conservator, he will temporarily relocate to Southeast Tennessee. Aubrey Preston also consults on financial matters relating to the healthcare industry. He invests through different groups in senior care facilities, including one that this court may be aware of, Morning Point, which is managed by Greg Vital. Mr. Preston has over 42 years of experience in the healthcare industry. He knows the difference in regulations for skilled nursing facilities versus have more regulations than assisted living facilities. He knows this industry backwards and forwards, Your Honor. He is willing to serve as the conservator in this particular case, and we have been through the other people that are statutorily set forth in there, and that is who may be appointed. There was a power of attorney granted to John McMillan. He has declined to serve as a conservator. There was a power of attorney granted to Lisa Lay. She has also declined to serve as conservator. There was also, in that power of attorney, Forrest Preston also named his current wife, Kim Fong Preston, now to serve, I think, pursuant to the affidavits and declarations we have. The statute talks about someone who is not only willing to serve, but who would act in the best interest of Forrest Preston. Clearly, that would not be Kim Preston, Your Honor. Despite an order from this court that Forrest Preston be examined, either Forrest Preston or Kim Preston have refused to have him examined. The President and CFO, as well as other executives of Life Care and board members and its affiliates, have sworn under oath that Forrest Preston is not mentally competent and needs assistance, and that Life Care is in a critical and immediate need of someone to act for Forrest Preston. And these declarations have been made with the knowledge that they could jeopardize their job, Your Honor. There's also a mentioning the affidavit from the osteopath. There's a case In fact, there are so many declarations from employees and executives of Life Care saying that he's mentally incompetent, Your Honor. And then there's this one conclusory report. We don't know if he's ever given a competency test before. We have no idea what, the qualifications from this person who gave the affidavit. But we do know that there is a case, it's Davenport versus Adair. And I have a cite here, it's a court of
Do you have a
appeal.
copy?
I do not have a copy with me, but I can furnish Your Honor a copy. It's a Court of Appeals out of the Western Section, 2005 case, and we'll get Your Honor a copy. And in that particular case, the court had heard actually testimony from one expert that said the person was competent, but there was lay testimony that the person was not competent, and the Court of Appeals adopted the lay testimony over the expert witness in that particular case, Your Honor. Your Honor, except for Forrest Preston, all the board members that were board members as of December of last year believe that Aubrey Preston is not only necessary to be a conservator, but he's the best person to serve as a conservator. His brother, Brian Preston, and his sister, Kathy Gooch, have also declined to serve and said that he would be the best person to serve as a conservator.
And just to be clear, we're not using, it's not a conservator today, it's an emergency conservator.
That is correct, Your Honor. Thank you.
There's a difference.
Absolutely, 100%
Right.
difference, no question about it. Thank you.
Was the Davenport case an emergency conservator situation, or was it a final conservator hearing?
Your Honor, I am not certain. I don't know.
Okay.
I did not look at it for that particular reason. In fact, I have to confess, I think Mr. Cochran is the one that told me about the case. So, Your Honor, I think we've shown today that no one else has the willingness to undertake such a massive obligation as this, to both care for Forrest Preston and to be responsible for the operations of Life Care and its affiliates, and that certainly Kim will not be acting in the best interest of Forrest Preston. And Aubrey Preston certainly qualifies under Tennessee law to act as the conservator for Forrest Preston. Based on all the evidence through the declarations, Aubrey Preston should be appointed as the emergency conservator, Your Honor, for Forrest Preston. And I would also point out, Your Honor, it's interesting to note that neither Forrest Preston nor Kim Preston are here in the courtroom today. Now, this is what we would ask, Your Honor, and this is detailed in our motion, of the powers that we would like to grant to Aubrey Preston as the emergency conservator. And we realize this is only for 60 days until the final hearing on January 13th, 14th, and 15th. These are the powers, and in light of multiple loans coming up, multiple things that have to be done, it may be we may have to come back before the court and ask for more, and I'll explain that in just a minute. But this is what we've asked. This is on page 12 of our emergency petition. That Aubrey Preston, in consultation with Todd Fletcher, Life Care's president, and in consultation with Steve Ziegler, Life Care's chief financial officer, will be authorized to make all decisions for Life Care and its affiliates that Forrest made in his role, vote all equity interests, which is important because Life Care is a corporation, but they're limited liability companies. We suspect there are probably limited partnerships out there. So we've used the term all equity interests, meaning anything, any equity that has in any type of entity held by Forrest and Life Care or other closely held business entities execute any and all legal documents, including contracts and lending documents, as if he were Forrest on behalf of Life Care and any other closely held business. Otherwise, start taking any actions on behalf of Life Care and its affiliates, including personnel decisions, such as hiring and termination of employees, as may be appropriate, and do otherwise take any and all actions reasonably necessary for life care and its affiliates. And Forrest is prohibited from making any such decision or taking any such actions, voting any equity interest, executing any legal documents, or otherwise taking any actions on behalf of life care and its affiliates, including the termination of any employee of life care and its affiliates. I'll stop there just for a second, Your Honor. We understand from discussing with some of the attorneys for life care that there are immediate loans that will have to be renewed. None of us in this courtroom, as far as I know what those lending institutions may be required. So as I'm going through what the powers we would like, I would say that if there is a lending institution that needs some more specific information or authority, we may need to come back and file a motion to have that specific language in it.
Okay.
Your Honor, continuing there are 5 things we're requesting. The next one is that Aubrey Preston, including through his agents, will be authorized to investigate Forrest's assets and all transfers from Forrest, directly or indirectly, and or life care or its affiliates, to Forrest, to Kim Thong, and I've used Thong's full name, is Thong Nguyen, that's her sister, Kim's sister. Dong is Dong Nguyen, that's her brother. Relatives of Kim Thong and our Dong, and any other person who has directly or indirectly received more than $50,000 in the aggregate during the past 2 calendar years. The third power we would like to vest in the emergency conservator for the next 60 days is that Aubrey, in consultation with the guardian ad litem, Ms. Lynch, sitting back here, will be authorized to make any personal expenditures of $25,000 or more for Forrest, whereas Forrest and Kim will retain the ability to make individual expenditures of less than $25,000. And that the fourth thing is that Aubrey is vested.
Is that 25,000 in aggregate before the January 15, or is it daily?
No, it's daily.
So
Yeah.
Forrest and Kim can spend $25,000 a day.
Your Honor, yes, that is correct.
Okay.
And if this court wants to limit more than that, or Ms. Lynch has a
I'm
different
asking you what
suggestion.
you're asking for.
I know, that's what I'm asking for. We realize the money at stake in this and how much is involved. I'll tell you I represent this to the court, from my discussions with John McMullen, that Mr. Preston, I'm not going to say it because it's open court, but there is a substantial amount running through his personal checking account on a yearly basis. I'll just say, leave it at that, without naming the figure. Hold on just 1 second, John. Your Honor, I was, excuse me. In consultation with Ms. Lynch, she thinks, and I've consulted with my other partners here, that $25,000 a week should be more than appropriate. And I will make a suggestion that can exclude any legal fees that he may be incurring in this particular case. So we'll exclude that. The next thing, Your Honor, that we asked for is that Aubrey Preston is vested with the sole authority to obtain or decline to obtain a passport for his father, Forrest. And whether Forrest is permitted to travel outside the United States, even at 91 years old, and Forrest is prohibited from, directly or indirectly, obtaining a passport outside of Aubrey Preston's direction and from traveling outside the United States as Aubrey Preston's direction and permission. And the last thing we ask, Your Honor, is that Aubrey Preston, in consultation with relevant medical practitioners will be authorized to make any emergency health decisions for Forrest. We are obviously concerned for his health, and we're only requesting this on an emergency basis. And at the final hearing, we definitely would request more relief as far as protecting his dad's health and welfare, Your Honor, as far as his health welfare is concerned. Just one second. Your Honor, we also request, Ms. Coffin pointed out, that, actually a couple of things, that we would request that Kim Preston allow Forrest Preston's family to visit him on a daily basis if they so desire, which has not happened in the past, as they've been excluded. And the last thing we would ask, Your Honor, is for an injunction to prevent Kim Preston from making derogatory comments about Forrest's family and about the employees and officers of Life Care. Just one second, John. The last thing Mr. Aubrey Preston brought up is that those visits with Forrest's immediate family, which would include his children and grandchildren, would be without Kim or any member of her family. They can be in the house, but not be with Kim or any member of her family. Thank you, Your Honor.
Your Honor, we're not here for the peremptory trial of the conservatorship affidavit. Those applicants haven't been cross-examined, there's been no discovery. We're here on the motion filed under 34-1132. The very opening sentence of that describes the scope of the court's responsibility under the statute. That is, if the court finds that compliance with the procedures of this title will likely result in substantial harm to respondents' health, safety, or welfare, then the court may consider appointing an emergency appointment before you have a final hearing in January. So the question, if you look at the statute, really it was intended to apply to a situation where there is an immediate need to address a health issue with the board. We do not have an adjudication of incompetency. We do not have any examination. I don't think Mr. Patrick was accurate in describing what is going on with the examination. Dr. Devlin is not the physician of Mr. Preston. He did have some occasion to have him talk to him years ago. He is a stroke specialist. Mr. Preston actually donated a substantial amount of money to his foundation, and they became friends. He has declined to participate in any opinion because he says, I'm not qualified to do that. He did refer to the guardian ad litem, a physician in Nashville named Dr. Schrag. And the guardian ad litem can speak for herself, but I think she's had trouble getting an appointment set up. Same with Dr. Ray. There is no refusal to participate. At this point in time, there is a presumption of competency. There's been no adjudication. So the question the court has to address is why appoint an emergency conservative at this point based on affidavits when we got a hearing set on January 13th. I think Dr. Smith is the only one that has come forward with an affidavit who's actually treated Mr. Preston professionally, and he says that in paragraph 4, I have no concern of Mr. Preston at any risk of substantial harm to his health, safety, or welfare. And he points out that his wife's been bringing him to treatment and taking good care of him. So why do this today? I did suggest to counsel and to the court, it's in my response, that with a presumption of competency, Mr. Preston could designate all other officers and directors with full authority to transact any business, especially with this one particular loan that should be closed by the end of the year before the hearing, and to authorize them to sign documents necessary to close that loan. This particular loan is being handled by Rich Faulkner and Baker Donaldson. I talked to Mr. Faulkner about that. I think he would like this reserved in the court order, this authorization, since we have these allegations of record at this point in time that he's not competent. Can you imagine him being able to try to get an opinion on closing the loan with these allegations on record? So having other officers and directors sign these documents in order to get past this loan without prejudice to anything that's before this court is doable. Mr. Faulkner would like to see the language of the order. So he's protected when he gives an opinion that these officers and directors were fully authorized to do so. So there is no basis for an emergency appointment. The court may or may not end up appointing a surgeon after you hear all the evidence and witnesses appear in court and cross-examined. Can you imagine chaos if you appointed an emergency conservator who undertook acts of this enormous company with 240 facilities, 40 to 50,000 employees, tremendous daily cash flow involving 1,000 patients, and you ended up non-appointed conservator. What chaos would have ensued if this interim conservator had done something with full power in the shoes of Mr. Preston, sole owner, the managing member of all these entities, and the chairman and the CEO? It would be better for the court to enter an order on an interim basis to let all other officers and directors, as I described in an attachment to the proposed order, to execute documents necessary for any necessary business until the court can have a hearing. That is the proper thing to do, rather than try this case on testimony of counsel or summary of affidavits. I'm not going to get into all the specifics, but I think it's important that these powers of attorney that were in the record back a decade ago, one of them, Mr. McMullen, a decade ago, appointed as executor a decade ago, appointment of Kim, I think Kim Preston and Lisa Levy appointed as co-powers of attorney. These are springing powers of attorney that come into effect only if he's adjudicated or he's determined to be incompetent by a physician, which we don't have his record at this point. I think the court has to ask, why was Aubrey Preston never put in another position? Why did his father never say Aubrey Preston should be the person holding my power of attorney, should be my executive? The reason is for that. Aubrey Preston is not an owner, he's not an officer, he's not an employee of these entities. He was probably 2 or 3 decades ago. He has no, you could almost argue that this is an attempted hostile takeover by forced emergency appointment of conservator. I guess there's a reason why his father had to put him in that position before. That needs to be explored. We need an opportunity for discovery and cross-examine these witnesses, and he needs to be examined as a court order. There's no refusal to comply with the court order. just hasn't been scheduled yet. So, in an interim basis, make sure this company is operating. And it is operating. Your Honor, it's actually doing very well since COVID ended. Occupancy is up, cash flow is great. They argue that Mr. Preston's not around much, but somehow, some way, this gigantic organization has continued to operate and thrive, even though he's not around much. So the management team must be doing a good job and must be holding down the fort. So I think the proper thing to do here is, if you want to put down an order, interim order on no, you can't leave the country. If you want to put down an order that he cannot bring him to the premises to involve himself in meetings, you can do that. If you want to put down any kind of order for protection in the meantime, that's fine. But to appoint an emergency conservator at this point, when we haven't had a full hearing, would be an extraordinary use of that statute, because there is no proof at this point that he is at risk of substantial harm to his health or safety. He's been taken care of. The doctor reports he was in good shape. That's the only thing we have in the record, Dr. Smith's affidavit. I also point out that Mr. Mullen is himself elderly. He's 88, I think. I understand correctly. He lives in Atlanta. Mr. Preston lives in Nashville. He does not live here. So I think this is a logical thing for the court to do. Rather than prejudge this case based on affidavits and argument of counsel, you can protect. The suit was filed for 3 reasons, so they say. One, make sure Mr. Preston's health and general care is being taken care of, and it is. There's no proof that that's going to happen. Number 2 would stop him from trying to convey money or assets to his wife of 6 years. That's a fairly debatable issue. His money, he's made it, he owns these companies, he's done very well. That's a debatable issue as a basis for appointing a conservator. The court can look into that. The third was to protect the company. That was the third reason. We got to protect this company that he owns. We got to protect it for the employees. We got to protect it for their patients. That's fine. But we can do that on an interim basis until we can have the hearing and prove what we need to hear. And that is what I just suggested. Having Mr. Preston, and he's agreeable to doing this, appointing these other officers directors for all of these entities that would need to co-sign this loan. And by the way, this is a renewal of a loan facility that does not require Mr. Preston's personal guarantee. It just requires pledge of assets to some of these facilities, one in Florida and one in Oklahoma. Now, Mr. Faulkner would like to see the language of the order and have some right to participate in it, so he can be assured that he can write the opinion necessary to satisfy a bank that the pledge of these assets has been authorized by officers and directors authorized to do so. So I think it would be a good idea for us to put this down in an order, that not only is Mr. Preston consenting to this, but the court is also ordering it, since there's some issue whether he could provide such a consent. But again, at this point in these proceedings, Mr. Preston deserves the dignity of a presumption of competency until there's proper proof to the contrary. And he wants nothing more than to protect all parties concerned, including what he's worked so hard for decades to build up, and the legacy he's built up. And this is a reasonable way to approach this issue at this point, rather than us trying a conservatorship by counsel argument and by affidavit.
Ms. Buchanan?
Your Honor, I was appointed to represent Mr. Preston as his attorney ad litem as it relates to the motion for appointment of emergency conservator. So I am trying to primarily focus on what's required for an emergency conservator to be appointed and narrow in on that scope. As your honor is aware, this conservatorship statute requires that a hearing be held on the issue of appointment of a conservator within 60 days of the date of filing. So the statutory provisions of 34-1-132 as it relates to the appointment of emergency conservator are narrowly tailored to apply in very limited circumstances. And the prongs of that threshold for that statute to apply is that the court finds a substantial harm to the respondent's health, safety, or welfare, and there is no other person to act or has authority to act or willing to act. And it references the Healthcare Decision Act, the Durable Power of Attorney Healthcare Act, and the Living Will statutory provisions. So there's an inference there that the appointment of an emergency conservator is related to healthcare needs and matters involving the person's person. There's been mention of this affidavit from Dr. Smith, and we did procure an affidavit from Dr. Smith, who has served as Mr. Preston's treating physician for the past 4 years. The purpose of that affidavit was to be in response to the motion for the appointment of the emergency conservator. We have not presented that affidavit in any form or fashion to be a determination as required under the statute and to replace the evaluations that have been ordered by the court. But that affidavit is to address whether or not there is substantial harm to Mr. Preston's health, safety, and welfare at present. Your Honor, I have studied this motion for appointment of emergency conservator, and there are basically 5 things that are broken down, which Mr. Patrick has covered in detail in his presentation. But number 1 was this scheme of Mrs. Preston to obtain assets. This court has already ordered, and I think we have submitted a proposed order, but by a conference we had 2 weeks ago, has ordered that there not be any transfer of assets or any usage of financial assets, personal or business, outside of the ordinary course of affairs. So there's a way to deal with that and has been dealt with by the court. Number 2, they cite as a reason for this emergency appointment is a history of abuse that Ms. Preston has to her children. You know, if you look at those documents that are in the petition for appointment, those go back to 1997 and 2006. And as we have shown in Dr. Smith's affidavit, he says that the treatment of Mr. Preston is appropriate and Mrs. Preston is then attended to have any of his health care needs seen to. Number 3, there is an allegation that this is needed because that Mrs. Preston has had access to the life care offices after hours using her access card. Well, presumably, if she has a personal access card, that was granted to her by someone within life care. And I believe there are ways that that can be sorted through and dealt with in the interim. Number 4 is the concern about the passport renewal and the concern that they would flee the country. I think there are ways for the court to address those concerns. And the 5th reason mentioned in this motion for appointment of emergency conservator is life care's time-sensitive needs. And as Mr. Horton has explained to the court already, we think there's a management team in place. The pleadings have, as Mr. Patrick went over, have indicated that Mr. Preston has been absent for weeks, even months on end from life care. But this management team has continued to operate this business with success. And we believe it can continue to do so without the need for an emergency appointment. Your Honor, I want to go back to something that Mr. Patrick read over earlier, and this is in his petition for appointment. And it goes to what they're actually requesting today for this emergency conservatorship. And this is on page 12 of 15, and Mr. Patrick's already went over these. But, you know, in conclusion, under number 6, they're asking, during this time, Aubrey requests the following modest authority to act on Forrest's behalf. And then they go into detail about 5 things they consider to be modest authority in the interim between now and January the 13th. And they've added a couple of other things today. So when you look at A, that Aubrey will make all decisions for life care, and including personal decisions as hiring and termination of employees. We think that's more than modest authority, and we think that's outside of the reach of the intention of an emergency conservatorship. B is that Aubrey is asking to investigate Forrest assets and all transfers from Forrest. Your Honor, we don't think that's a reason for an emergency conservator to be appointed, or authority that they should be given in an interim between now and January 13th to make those investigations. We think the discovery process of the conservatorship will lead to those things being disclosed and appropriate to be discovery measures. C is that, and the court has already looked at this, that he could make any personal expenditures of over $25,000. D is that he be vested with sole authority to obtain or decline a passport, and E, that he would be authorized to make any healthcare decisions for Forrest. Your Honor, we just think this exceeds the modest authority requested, these requests, and we think it exceeds the need and necessities of the authority that would be given to an emergency conservator. We think the court needs to focus on whether or not there is substantial harm to Mr. Preston, and we believe not, if there were not to be an emergency conservator appointed in this matter. As Your Honor is aware, there are provisions in the conservatorship code that provide that the court is to look at the least restrictive alternatives to appointment of a conservator. And I know, we are here on the appointment of an emergency conservator today and not on the appointment of a true conservator today. But I think that can also provide guidance to the court today about consideration of least restrictive alternatives. Your Honor, I think all of these 5 concerns that have been outlined in their motion are certainly things through appropriate court orders. An order of this court can be addressed, and we even agreed to some of those measures being put in place. And that eliminates the need for any emergency conservator to be appointed in this matter. In the alternative, Your Honor, I would like to point out on Mr. Preston's behalf that Mr. Preston has never chosen Aubrey Preston in any manner to act for him as a fiduciary. As put in the record by the plaintiffs in this matter, there is a power of attorney by Mr. McMullen in 2016. There's a power of attorney given to Lisa Lay and Kim Preston in 2020. So going back at least to 2016, Mr. Preston has never chosen his son to act in a fiduciary capacity for him. And I know that will come up later in these proceedings when it gets into statutory priority. As the court is aware, that should be given to persons that the person has recommended in their appointment that they have made during their own powers of attorney. I recognize that we currently have 2 people that have declined to serve, and I think it's unfortunate that people that have been entrusted with those responsibilities have, for some reason, declined to act when the time may be to act. So, Your Honor, in summary, I'm asking that the court decline or deny the motion for an emergency conservator to be appointed, that the court make a finding that there is no present substantial harm to Mr. Preston's health, safety, or welfare so that it is not necessary to appoint an emergency conservator. But if the court does find that there are measures to be in place, as I said, we're not disagreeable to some protective provisions being ordered by the court that would address in the interim until January 13th any of those concerns that have been raised. Thank you.
I'd like to hear from you on one other issue.
Yes.
You're appointed by the court under this emergency statute. It appears that Mr. Preston or someone acting on his behalf has hired counsel. Is there a need for 2 counsel?
Your Honor. Well,
Madam
speaking.
President, I did ask counsel to stay involved. This is because I had health issues before we got, but I think she's helpful. I would ask that she be allowed to continue.
It's not whether I'm allowing it, it's whether I need to continue it under the statute. Now, if you choose to hire her separately, that's a contract between you and her at that point, unless the statute requires me to keep her on.
I understand.
Your Honor, I think the statute allows for the attorney ad litem, and I was appointed for this specific role for this limited purpose.
Right.
So
For
I think
this
after
hearing.
today, my role does end, unless I am either asked to stay on by some party in this matter. Also, the statute caps the attorney ad litem's fee at $1,500, so there will actually be a request that this is a complicated matter under the statute when we do make a request for fees.
We will waive that. Check, you know.
All right.
Thank you.
Anything else?
Your Honor, my name is Madeline Biker with Hush Blackwell, and I represent Ms. Kim Preston. I understand that Ms. Preston is not a party directly to this petition, but she does have statutory priority under the conservatorship statutes, and if you would allow it, I'd like to address Kim's position with respect to the emergency petition.
I don't know that she has standing at this point under the emergency conservatorship, but I will allow you to address the court.
Thank you, Your Honor.
Give me your name, Madeline.
Madeline Leonard Biker.
Okay.
First and foremost, Ms. Preston denies the scurrilous accusations and allegations made against her in these pleadings and in this court today. But today is not about Ms. Preston, it is about Forrest and the need for emergency conservator. Kim supports the positions set forth by Forrest's counsel today, both of them. But if the court finds that emergency conservator is necessary, Kim has no desire to run life care, to be in charge of business decisions, or to manage Forrest's personal finances. Kim is Forrest's wife. She has been for 6.5 years. All Kim wants to do is to continue taking care of her husband, and she has taken care of Forrest's health care needs well, and there's no evidence to the contrary. And so we would submit that Aubrey is wholly inappropriate to serve as an emergency conservator. If the court chooses to appoint one for the same reasons that were presented by Forrest's counsel. And we would ask the court to deny the motion.
All right. Mr. Patrick, anything else?
Just briefly, Your Honor, and I will not prolong this. It is interesting to note that there has been a lot of argument of whether a conservatory is needed or not, but the only proof is this one affidavit from a person that we don't know is even qualified to administer a competency test. We don't know if he administered a competency test. We have to assume he did not administer a competency test. But without question, Forrest Preston has not complied with this court's order to be examined. So that's zero question. All the other statements that have been made up here by the other side are just speculation. There are no declarations. There are no affidavits. There's nothing. We have the entire management team, the president, the chief operating officer, the chief financial officer. We have multiple people saying that, board of directors, John McMullen, saying that Forrest is incompetent, that he cannot understand the day-to-day affairs of life care, and that Aubrey Preston needs to be appointed. Why wasn't Aubrey appointed as executor? This is one of the children, and there are several children. Mr. McMullen was appointed. Obviously, you don't want to get one child against another child. Easy to explain, Your Honor. And we think in this particular case that the health, safety, and welfare of Mr. Preston absolutely requires an emergency conservatory, Your Honor. And with respect to the harm of Kim, we have a declaration from Janice Say. And this is why we requested daily meetings with Mr. Preston by his family members. Janice Say is the personal assistant of Forrest Preston. And in paragraph 7 of her declaration, this is exhibit 3 to our petition, she says, during this same meeting, Kim raised her left fist at Forrest, bearing her wedding ring and asked him if he wanted to knock out his other tooth. At the time, Forrest was already missing one front tooth, and Kim did not do this in a joking manner. And Forrest did not respond to her as if she meant it in a joking manner. Forrest had been missing at least one tooth for several months, and he was missing this tooth when Kim threatened him during the meeting. So, yes, there is substantial likelihood of harm not only to Forrest without the request that we made, but also substantial harm, and I was going to say critical harm to Life Care, its employees and its patients, Your Honor. So we think if there's ever a case that needs an emergency conservator, it is this case. And it is unanimous from the entire management team at Life Care and everybody else that knows this situation, that Aubrey Preston is the person to be appointed as the emergency conservator.
All right.
Thank you.
34-3-105 provides that if the respondent refuses to have the examination, the court shall, it's not discretionary, order the respondent to submit to the examination, and under section F, the examiner shall shall provide a report to the court which under 105F will remain confidential and under seal. That is to be complied with. The guardian ad litem is in charge of setting that up. Failure to comply may result in a contempt petition to be filed. Dr. Smith's affidavit does not outweigh the lay testimony on certain issues in this case. Certainly I have questions about Dr. Smith's qualifications and or any bias there may be. So I certainly hold that with a little less weight than what I do with the current management team, as they have been called, who've all given affidavits concerning Life Care. When also coupled with those affidavits, I find that under the statute, the 34-1, is it 101? It's the emergency conservative petition, excuse me. 132. Yeah, 34-1-132, this 132, this court finds that compliance with the conservatorship procedures are likely to result in substantial harm to Mr. Preston's health, safety, and or welfare, specifically his vast business interests pursuant to the affidavits filed with the attachments require this business and certain business decisions to be made timely, and some of those that have been conceded need to be made before we can have a hearing in January. No one appears to have the authority to act or willingness to act or stand and is acting in the best interest of the respondent. So this court will appoint Mr. Aubrey Preston as the emergency conservator. However, the court will limit the authority requested by Mr. Preston in just a second. This appointment, as the statute notes, is for 60 days, and the court will note this is not, and I will repeat, is not a determination of Mr. Preston's incapacity. That is not the matter for this hearing today. That is the matter that is set for hearing January 13th through the 15th. In looking at the powers requested, I find those listed in the petition on paragraph 12. Section A is reasonable with certain limitations. Mr. Aubrey Preston is limited to only decisions in the normal course of business, and that would be declined as those that cannot wait for decision until January the 13th. And they must be made in consultation and agreement with Todd Fletcher and Steve Ziegler. Number B It is not necessary to give the emergency conservator authority to investigate transfers at this point. That would be something that would be requested by the regular conservator if in fact one is being, one is found to be necessary. I do give Mr. Aubrey Preston the right to withhold passports. I do give him the authority to make emergency health care decisions. I do give him authority to allow or disallow family, meaning the children and grandchildren of Mr. Preston to visit him on a weekly basis, and Aubrey Preston can visit on a daily basis. And that is to be without the wife present so that they can have their private time with him. The injunction against him to not make derogatory remarks is not in proper procedural filing at this point. Kim is not a party to this case, and she hasn't been given notice of that request and an opportunity to respond. The attorney ad litem's role in this case is terminated. She is free to be hired by Mr. Horton, who is counsel for Mr. Preston in this case. Is there anything I've left unanswered at this point? The weekly budget of $25,000 seems appropriate. And Mr. Aubrey Preston will be the one who consents to health care, any emergency health care. Okay, anything else?
I'm fine, thank you.
Well, Your Honor, you say emergency health care, what about
Yes.
routine health care?
Routine health care is the wife and Mr. Preston who make those decisions. In other words, I don't want Mr. Aubrey Preston to have to be involved if he's got a sinus infection or something of that nature.
Thank you.
Thank you, Your Honor.
All right, anything else?
Your Honor, with respect to the required medical examinations during Catherine Lynch for the guardian ad litem, the court in its October the 29th ordered examinations by Dr. William Ray and Dr. Devlin, or Dr. Devlin could refer.
Yes.
At this time, I have secured a position, actually a neuro surgeon in Vanderbilt, along with a neuropsychiatrist. And so my question to the court in terms of instruction is, may we release Dr. Ray?
Yes.
Thank you.
All right. Thank you.
All rise.